Hi, everyone. We're pleased to bring you this presentation today as a part of the DuPage County Bar Association. The presentation today will be covering rights under commercial leases, specifically as it relates to the impact of the COVID-19 pandemic on tenants and landlord rights. So without further ado, I would like to introduce ourselves. Alyssa, do you want to fast forward the slide? Thank you. So our speakers, our speakers today include myself. I'm Liss. I'm an attorney with Liss and Lamar PC in Oak Brook. Contact information is there. My practice involves a lot of representation, predominantly of tenants. Most of my clients in the leasing world are retail tenants, some office, some industrial, but probably 80% retail. And then I will let my co-presenter, Alissa, introduce herself.
Hello, my name is Alissa Verson. I am an attorney at Carter & Taney in Wheaton, and my information is right there as well. Similar to Laura, most of my clients where I negotiate or do other early dispute resolution with leases are with retail tenants, but do also have some office lease work as well that I do.
Great. Okay. Well, without further ado, Alyssa, do you want to take us to our next slide?
Yes.
Thank you.
Okay. So today we're going to start off by giving you a summary of what's happening in terms of rent relief for tenants as a result of the COVID-19 crisis and trends that we have observed in our practices between March and May of this year. Since this is a completely new world to everyone, we think that it's a really important dynamic topic that is just continually changing. Then we are going to go through some lease provisions, reviewing them and showing you how potentially you can negotiate beyond rent relief, things that we have negotiated in the last few months, thoughts that that we've had or clients that we've spoken to and having given advice to them based on the leases that we had previously negotiated, with them before, this was on our radar. And then we're going to go on and give some thoughts and advice for ongoing or new lease negotiations, including sample language that we have used in our practices specific to COVID-19.
Great. Okay. So let's start with kind of where we are. We're not going to do a whole background on COVID-19. I think probably everyone knows about it, or if you don't, you're certainly able to open up the internet browser search of your choice and look that up. But respecting our particular topic today for commercial leases, I think that it does bear some, summary, so to speak, of where we are and kind of what we've been seeing in the trenches for the last couple of months. Here, I think that we've seen a lot of tenant clients who have been asking for landlords to either defer or abate, meaning forgive and not require payment of their rent for certain months. I mean, certainly tenants would love it if that would go on indefinitely until we had a vaccine. But because landlords are a business as well, they are not able to understandably do that indefinitely. I would say that, we are seeing a lot of this happening. There's very few cases that I've seen where a landlord will not give some kind of relief. It may not be exactly what the tenant, hoped and dreamed for, but it's not to say that the landlords are being completely inflexible either. And a lot of that, not a lot of it, but one of the factors that can really play into whether or not and how much the landlord is willing to accommodate a tenant can be seen with the relationship that they are either a private landlord or that they are an institutional landlord, for example, where the properties are bundled into a real estate investment trust, a REIT, or, they are a large landlord. And so, having too many hits, right, really might, capsize the boat. Alissa, do you want to speak to the next points?
Yeah, I mean, just to continue off what you're saying, I do think that landlords are understanding and realistic in some ways, because they see that they could potentially lose a large proportion of their tenants because of the stay-at-home orders, because of the executive orders by the governor. And so and also they don't see the potential, if one of their tenants leaves, that they're easily going to be able to relet that space.
They do not have a strong pipeline right now of replacement tenants in the event that they were to decide to be inflexible and do evictions. You're absolutely right that it is a symbiotic relationship right now. And so everybody needs to kind of be rowing together.
Mm-hmm. So yeah, I mean, in addition to whether you're working with a private landlord or an institutional landlord who may have, several different shopping centers, like Laura was saying, the relationship with the landlord is also very important. Have the tenant and landlord had a good working relationship? Have they been been current and in their rent and other obligations to the landlord, and vice versa? But also the length of the relationship. I have one client that we're going to discuss a little bit later, who happened to have a 15-year relationship with their landlord. And so a landlord that has 15 years of good experience with a tenant might be a little bit more willing to negotiate than someone that has a more short-term experience. I know a client called because they held off on lease negotiations for a second location, because their first location, they own a fitness type business, and their first location had to close, and they'd only had 2 years of previous experience with this landlord. And so that's a very different situation, 2 years versus 15.
Right. Even, I mean, some people may have only been in their space and open for 6 months. I mean, anything is possible. It's not surprising, especially for the fitness businesses, to use your example, that because they all want to be open right in time for the new year, but they don't want to be open too much before that if they're new, that they may have only been open for 2 months. They opened in November, kind of got their feet wet, and then they were supposed to, they had this big splash in January, and now they don't have that relationship, like you're saying.
Mm-hmm. And then, there's also a difference between small businesses who have received PPP loans and those that have not, because, a portion of PPP loans can be used for rent. And so, a landlord, if they know that this, this small business, this tenant has that income stream, they might not be as lenient to give, some sort of rent deferral or rent abatement.
Absolutely. And I think that's really important to note, because most of the landlords, they've had a couple of months to figure out what their process is going to look like, for how are they going to evaluate these requests. And really what they're finding is that, they've come up with questionnaires. And one of the really important questions to them on there is, for the tenant to explain if they have gotten PPP money. That would be the Paycheck Protection Program that came out this year as well, to help business owners. And if they have gotten that, the landlords will not be quite as interested in rent relief, unless they can show something where they have, they really just have to pay their people. But that would probably be more in a situation where the business, is open, for example, if it was essential.
Right. And then, speaking with other tenants of the same landlord to see what they're doing. I mean, in some situations, if there was some sort of negotiation with the landlord, likely the landlord will require that those negotiations are
Confidential, but
thank you.
Okay.
Yeah, so that's it. It's it's a good resource, but also there could be some roadblocks.
I think, I mean, tenants talk, everybody talks, it's not to say that we should be encouraging anyone to breach their confidentiality obligations, but the reality is that, if you're all in the same shopping center, you may know the other tenants, the other tenant owners that are in there. Some of the shopping centers even have, marketing associations where the tenants all sit on a board, to advise the landlord how to market the center. There is no harm in reaching out to at least bring it up and try and see what else is happening.
Right. And then one, other thing that's coming up, just in a couple days is phase 3 in Illinois, and different types of businesses that are able to open if they do comply with Illinois Department of Public Health or CDC guidelines. And so, but some of those types of businesses, there are stipulations. They can only have a certain capacity. One thing is that some fitness services only can have group classes that are outdoors, and they're limited to a certain number of people in attendance, and that might not be sustainable for their business model. Different things like that, where
some things can go outside super well. I mean, like for example, like a Pilates studio that has the reformer machines, those are not easy just to move in and out. So it sounds like a great idea until you realize, it will not solve all of the problems to do it outside.
Exactly.
Okay, so we'll do the next slide. Great. So beyond rent relief itself, we did want to include some other provisions in this discussion that we thought were particularly important because they are frequently tied to whether or not the tenant is either or both operating and not in default of its lease. So Alissa, I will let you advance the slide. Okay. And then you want to talk about force majeure?
Sure. So I think that the issue of force majeure certainly depends on the lease, on the lease itself that you are reviewing or negotiating, and making sure that you're asking the questions: is this force majeure broad enough to encompass something like this COVID-19 pandemic? And a lot of open questions right now in this area is a global pandemic an act of God? Because a lot of force majeure, they list an act of God as, they
not list a pandemic, but they do list an act of God. So now we have that debate, right?
Right. So that's, a current debate. And one thing when Laura and I were prepping this was, talking about how financial hardship in itself is not a reason, that there would be a force majeure event. It's not, it's not
usually expressly excluded from the definition of force majeure in most commercial leases. And I will say that, a lot of, it is worth repeating that like loud and clear to a lot of people. I was on a call less than a month ago, a real estate tenant, call with the broker, with the landlord's broker, we're at the final call, where we got to talk about, the last 3 things that are open to negotiate. And my client's broker, so the tenant's broker, was basically encouraging my client to walk away from asking, for the, basically asking for some abatement related to COVID-19 to be in the lease, thinking, incorrectly, but thinking that the force majeure clause was going to cover it. And I had to be the one, unfortunately, on my own side to sort of re-educate my client's broker that this was, rent relief was expressly excluded from the impact of a force majeure clause in this lease, as it is in probably every lease I've ever done. Because it's not something that we usually even try to negotiate, because before something like this happened, there really, it was really going to be a brick wall to negotiate against. So I think it is worth shouting from the treetops to remind people about that, because they're not necessarily getting the correct information, maybe from their different trade groups or things that they're reading, that force majeure does not typically provide rent relief.
Right. Yeah, so I think the big debate right now would be, where is the line drawn between, financial hardship and then, and also these, restrictions that have been, imposed by, local, state governments. And so, is this a bit, what type of business is it? Is it a business that, has been able to keep open, but has suffered, from a decrease in sales? Is it a restaurant that, had a lot of, that most of their income came from, sit-in service, but now they're only doing,
Or it was like a sports bar, and there's
right.
not really sports on right now. Plus they're having to be closed. Plus, alcohol, was a big part of their revenue.
Mhm.
Those guys are really affected.
Exactly. So it's kind of, what really, what really is it that's causing their financial hardship? Is it just that people,
Causing the hardship, right?
what is it, just that people aren't coming out because, they don't want to expose themselves? Or is it because, they're forced to close, or they're forced to only have a certain, capacity? Yeah. So it's a kind of
It's a big discussion point for what is, especially on an ongoing basis as we start to reopen, because right now it's been fairly black and white that the reason that people are closed is because they legally have to be closed. But as we start to reopen, like Alissa was saying, we're about to go into phase 3 where more reopening will be permitted. We will start to have more of that question about, what is the reason that the business is not, doing well, basically, that the rent relief is being requested.
Yeah.
Do you want to talk a little bit about the Jenner and Block?
Yeah, no. So I, in, kind of preparing for this, I came across an article. There is a current dispute between Jenner and Block and their Chicago landlord, because prior to the COVID-19 pandemic occurring, the last time that they had negotiated their lease, they put in, they negotiated a provision for rent abatement in the event of a situation like a global pandemic that renders the firm unable to use and occupy the space for its intended purpose. We don't know the conclusion of, of this litigation yet because it's ongoing. I know that the tenant, did, credit the landlord for the limited space that they are able to use for its intended purpose. But there's a city. It's in
this one is fascinating. Yeah, it's fascinating also because, one of the essential industries are law firms. That law firms are permitted to continue to operate, with the preference being that everybody stays home if they can. But it is sort of a wrinkle to their argument, and so it will be interesting to see how that plays out. Okay. So some of these other sections that we wanted to address, make sure that people were thinking about beyond rent relief, these would cover things such as exclusive use rights. If you're not familiar with exclusive use rights, we see these a lot in retail settings, especially where someone wants to be the only place that sells pizza, for example, in a shopping center. Domino's franchisee does not want a Little Caesars franchisee to be able to, open 2 doors away from him or her. Or we see this with fitness concepts, I don't know, an Anytime Fitness doesn't really want another, like a Planet Fitness coming into the same center for fear that it will cannibalize each other. So most tenants in the retail setting, when they are negotiating their lease, will ask for, what is commonly referred to as an exclusive. And so these exclusivity rights, though, are typically contingent and dependent on one, that the tenant is continuing to operate under the use, with the fitness business, with the pizza business, and they have not converted to doing something else, and that there are no defaults under the lease. Otherwise, it is usually the case that the exclusive will automatically expire if it were to be the case that there were defaults or the use changed. So it is worth mentioning to your tenant clients that if an exclusive is important to them, they should really be looking at this, to have something in whatever they're going to sign with the landlord that is for rent relief. Hopefully they're getting some. Now we would also recommend that they be having an acknowledgement at a minimum that, anything, related to the COVID-19 pandemic is not going to affect their exclusivity rights adversely. And I think that most landlords will understand that because, we talked about, there is a limited pipeline right now. So I'm not sure they're going to get another pizza franchisee or, fitness business, what have you. But it is worth mentioning because, the thing about leases is that because they are for such a long time and properties do change hands, that even though it was the practice of, let's say, the current landlord, if the current landlord sells off or is forced into bankruptcy and the property changes hands, your tenant client is going to be stuck with someone new who may be looking to come in and, proverbially crack the whip. So it's worth documenting because these properties do change hands, whether it's voluntarily or involuntarily through bankruptcy.
Then we can go on. So another provision to think about are co-tenancy rights and remedies. One of my favorite provisions to negotiate is the anchor tenant provision, because if you scope out, if it's a small business, you scope out a commercial space that is near a grocery store, it's near a Kohl's, a Target, those are the types of major retail spaces that are getting the traffic in, and if they leave, the traffic severely decreases, and so if that anchor tenant leaves the shopping center, they want to be able to terminate the lease. Although then, in this situation right now, the landlord might have, some defense because this anchor tenant, whether if it is a grocery store, it's essential, it's going to stay open. There's still going to be that traffic, but then if it's something like a Kohl's, and all the Kohl's are closed right now. So I think it just depends on on what type of anchor tenant it is, and
right, and what's really happening to the anchor. Is the anchor closed or have they actually left the center? We're starting to see more bankruptcy filings where different store brands are going to shed off let's say 20 or 200 whatever stores, and that's stores that are just kind of basic all the way up to I think Nordstrom is closing stores, and so there will be co-tenancy, anchor tenant issues, especially as this continues. So it's something to keep in the back of your mind for your tenant clients, that if they are in a setting where they have co-tenancy rights, that even if they they got rent abatement, they're okay right now, but they would be devastated if the Kohl's or the Macy's left the strip center. They need to be aware of that they have that, hopefully they have that.
Right.
So our final one on this slide, it sounds almost too basic to mention, but it is worth mentioning. And that would be operating covenants. The biggest one, that Alissa and I were thinking of is that, the lease does require that, commercial leases require that the tenant be open and operating typically. It's not enough just to not be in default. You're not allowed to just have the space, but let it be dark, because landlords usually do not like dark, unopened businesses in the center. They draw negative attention, is the landlord's opinion of that. And so, we are trying to encourage tenants to make sure that, just like they are thinking about, exclusivity not being lost, we want to make sure that they are not potentially going to be held to be in default if they are not actually open. And again, when they weren't allowed to be open, that was kind of without question because it's a government order. However, as we're starting to come into phase 3, there may be businesses that say, they try being open for a month and they really are just losing so much money by having to staff that they decide not to be until, you know, we get to some further stage. And so that would be a situation where it would certainly behoove the tenant, you know, to try and negotiate something with the landlord to say that they do not actually have to be open and operating in the space, and they can't be defaulted for that during this time. Okay, shall we proceed?
Yes.
Great.
Okay, so we'll go on to some thoughts and advice we have for ongoing or new lease negotiations, whether they're, you know, negotiating an abatement in rent, deferral of rent right now, rent waiver, which would be the best situation, but you know, is
Yeah.
not really.
Or people who are just doing new businesses. I mean, I have a few that, you know, they're just doing new leases. You know, like I have this note here about development of raw land. You know, I have a few that, you know, they're looking to actually still do, like, it'll be like, you know, 9 months of, you know, doing it. So they're not really that affected by this, because they feel pretty confident that in 9 months, you know, we will have made enough progress that they will not really be at their operation, at least will not be adversely affected. So there are people out there, not very many of them maybe, but there are people out there who are still looking to, you know, lease. And so we are looking at, you know, for those clients especially, how do we protect them if they're either going into a lease negotiation for a modification, like Alissa was saying, or just an entirely new lease, because we can't pretend that we don't all know what might happen now.
Yeah, like I was saying before, I had a couple leases that I was in the middle of when this happened, and you know, my client said, you know, hey, sorry, we need to figure everything out, and we're not going to, you know, go forward right now. But you know, but if it's the type of business where they can open in phase 3 or phase 4, you know, certainly, you know, there could be a continuation of those negotiations for a new lease.
For sure, for sure.
So,
okay, so let's go to the next slide. And this is my attempt at a joke. I mean, we're lawyers, we're not always that funny, but we are looking ahead. None of us really know what's out there exactly, but we're going to try and at least give you, as our audience, some sample language. I have tried to make this legible, even though it is very wordy on the following slides. I would encourage you to email either of us to get us to just send you, you know, in an easy to use version, the text. We will not feel like that's weird or anything. So our emails are in there, you know, feel free for any questions, or just you say, I just want the language. And that's fine as well. So Alissa, do you want to go to the first set of language?
yes.
Okay. So this is drawn from a lease that I am negotiating at the moment. Maybe we'll still make some tweaks to it, but this was the landlord's proposal after we asked as a tenant for some kind of, you know, written policy for a new lease. Okay, this is someone who has never been open yet, never occupied the space. What would the policy look like in the event that this returns in the fall or next year, let's say? So it's written to cover like the next 2 years or so. And I think it's actually pretty helpful. It is pretty verbose. You know, it takes me like 3 slides in here to put all of it together. So that's how it is. But I think it is a good example of a very particular business disturbance clause. So, you know, you'll see in here that we have a reference to, you know, from whom, you know, what government agency the pandemic order is, you know, coming from. We'll see, you know, that there's a notification period. There's, you know, a documentation request explaining the disturbance, which I think is fair under the circumstances. We certainly don't want, you know, the landlord to feel like anyone is unjustly claiming it. So, Lissa, can you advance the slide, please? Okay. And then, you know, we have an amount and a period for the abatement. And basically, this is written that there are 2 opportunities, essentially, for abatement. You know, again, like I said earlier, it's kind of unfeasible to expect that the landlord is just going to give unlimited abatement. They need to know essentially what their potential exposure is on this point. So I feel like 2 abatement periods is actually pretty good. You know, this is not a case where we, you know, this tenant in my negotiation is a very large occupant either. You know, we have the usual, you know, 2,500 square feet in the shopping center. So, you know, they're fairly pleased with this. And the landlord, you know, it feels like it's fair too, because they know what their exposure is. Alissa, have you started seeing anything like this, you know, for other tenants that you're starting to resume working with?
No, because I would say that, you know, the leases that I was in the middle, the middle that I was in the middle of negotiating a new lease
Everybody.
they were all businesses
Yeah.
that aren't even, they can't open yet, and they're not even, you know, and then maybe their other businesses are struggling, and so they're not even thinking
Right.
about it at this
Yeah.
moment. So this will help me
Oh,
when,
good. I'm so glad. I'm so glad. It's already helping someone. That's excellent. Okay. Do you want to advance the slide again, please? Okay. So then, you know, and we do have some language in here, you know, for example, kind of starting in the middle where if there is a default, you know, let's say that they, I don't know, were doing something else bad, or they, I don't know, had a window broken and never replaced it, the kind of thing that is technically a default under the lease, other than payment defaults, then that abated rent is proposed that it will come due. So there is a trigger, basically, you know, it's be nice to us and we'll be nice to you type feeling. And it's also, you know, they have restricted it also to kind of keeping it to what the business has been proposed to be in the case that this is a new tenant. So they want the normal business operations to be defined. So, you know, it could be that it's a, you know, whatever, anytime fitness, you know, fitness business or something for the business trade name and type. Because they don't want, you know, something else to go in there that maybe isn't restricted and then they get a benefit. So that was the first one that I saw. I don't know, Alissa, do you have anything you want to add on that, or it's okay if not?
no, I think.
Okay. And then I'll just run through this one. This is drawn from that same lease where the tenant does have some build out, and this is providing for a delay in the commencement date in the event that there is a, you know, defined like COVID delay. I don't know how relevant this will prove to be because construction has been a permitted exception since the beginning of the stay home orders. So I don't know that this will be super reliable, but it is generous, at least that the landlord is giving it to us, as opposed to just saying, well, but construction is a permitted exception, you know, why do I have to give you that? So I'm pleased that we're getting it. And then the next one, Alissa had done a lease that kind of, I'll let you talk about it, sorry.
So I mean, it was a negotiation between an existing tenant. This is the tenant that I was talking about that had been, you know, a tenant of this landlord for 15 years, and so they had, you know, a long history, long landlord-tenant relationship, you know, and they were able to have a deferral for 3 months, so April, May, and June of 2020. But you know, this is
That
different.
worked out well.
Yeah. No, so it did work out well, like in terms of the, you know, the stay-at-home order and the, you know, the government regulations. But the deferred rent, you know, it does come due. So that's like the, you know, that's the issue here. You know, it's in, you know, monthly installments starting in July, in addition to, you know, the rent that they're already going to have due. And so, I mean, it is a really good, it's, you know, it's a really good step. It's a really good, you know, negotiation to, you know, to give them some relief. but, I think you still need to think about the fact that, they're going to have to spend more, and in July, there, it's likely that they're still going to be, it's a retail, it's likely that they're still going to be struggling and not be, at their, their normal gross sales.
Yep.
So it's,
And I think too, sometimes, depending on what kind of industry this is in, um, what they might be making in the summer may not be as much as what they would be making in other months. I assume that they've thought about that because, they picked this timetable and whatnot. But if you are working with a client on that, not only are you considering, COVID related, lower gross sales than normal, but also seasonality, to say, okay, if you usually sell more stuff in the winter, make sure that your repayment of a deferred rent doesn't kick in July. Try and say it won't kick, if you have a ski shop or a snowmobile shop, try and say that it'll kick in December.
Yeah, that's a really good point. I mean, this retail business happens to be, very popular in summer, and they have, and so I think that it is, good timing in that way, although because, it is just, 2 months away, there's still, some question marks as to how it's going to work. But yeah, I mean, again, the terms were were confidential between the tenant and the landlord, so the tenant cannot, tell any other tenants of this landlord that they were able to negotiate this. Yeah, so it helps, and but obviously the best deal for your client is getting some sort of
right, and
or a waiver, instead of a referral.
It is, and I think that it's really important to emphasize, just as a closing note, that all of these negotiations are really going to vary per tenant, for all of the reasons that we said at the beginning, and just because their businesses are different. The landlords are different. So there will not be, a consistent response. Frankly, the way that the leases are set up, that payment is never excused under force majeure, basically forces all of these to be, very tenant specific negotiations. And I don't think that that's necessarily bad, but just as a practice matter, we can start to see trends, but we can't always rely that, we can tell a client what to expect from them the way that we could, about a different provision of a lease. When I represent a tenant, I can tell them, yeah, I don't know that I really see anyone agree to change, whatever such and such section, we can ask for it, but, I can just give them a heads up. Whereas here I'm like, I'm more enthused just to like ask for whatever and let them tell me no and not negotiate against ourselves.
Right. I think, landlords and tenants are both at a disadvantage right now. So it is a little bit more of a,
more of a free for all, like, which I'm okay with. So, well, do you want to advance our slide? So thank you for everyone who has been watching this.
I hope it was helpful to your practice, and something that you're working with.
We would definitely encourage anyone to send us questions or call us. Our phone numbers and emails are there on the screen again. And we are very available. We represent both real estate clients, business clients. Alissa and I have a surprisingly similar client mix. So there's really no difference if you call one of us or the other. I don't think one of us does anything more or less, percentage-wise of our practice. So hopefully we will hear from some of you, because that would be actually exciting to hear more of what's going on in the marketplace, frankly.
But it would be your own practices, I think, just, to speak to your attorneys that are dealing with the same issues, for sure.
Right, absolutely. So we will sign off, but thank you so much for attending, and we hope that this was helpful.
Thank you.
Thank you.